Wolfteis Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern and Southeastern Europe.
Welcome to this episode of Wolfteis Soundshot. Today we'll try to answer the question if competition law has become greener and more sustainable. Some of the listeners have probably followed the fierce debate in the last years about which direction competition law and also competition policy should go to encompass essentially the green transition of our economy. Today we'll talk about the status quo, and we will be not just talking about antitrust, but also about merger control and state aid. I am Martin Gassler. I'm a member of the Competition and Antitrust Practice Group here in Vienna, specializing among others in Austrian and EU competition law. And for this topic today, I'm very honored to introduce two very distinguished guests. So Sonja Rentz, she is a lawyer that currently works for the Austrian Federal Cartel Prosecutor in Austria, previously worked for the Austrian Federal Competition Authority, so these are essentially the two competition agencies in Austria, and she dealt among others with sustainability in competition law.
Hi, thank you so much for inviting me.
Thank you for coming. Also Moritz Schwarz, he is an economist and doctoral researcher at the University of Vienna. He is a former practitioner of competition economics with several years of experience, including policy experience related to sustainability during his time at the Federal Competition Authority.
Thanks, Martin. Pleased to be here.
Thank you. Thanks both to you for coming. I should add that you both speak in your private capacity and that your opinions do not necessarily reflect the positions of your current and former employer. Okay, so with this out of the way, let's start with one of the areas of competition law that has been heavily and fiercely debated. So that is antitrust, and to be more precisely, that's the cartel prohibition, so Article 101 DFEU. And before we start, I just want to give a short background to what happened at the EU level in the last years, and so that our listeners have a rough overview of what happened and where we are right now. So back in December 2019, the European Commission announced the Green Deal, which essentially is a very ambitious goal to make the EU climate neutral by 2050. It was roughly at that time when the Commission also started the evaluation of the horizontal guidelines. So these are guidelines issued by the Commission that essentially are aimed for companies to self-assess their agreements with other competitors. And so in March 2022, a first draft was published, and which was followed by a public consultation. Quite a debate, I have to say, and roughly a year later the final version was out. And the end result is essentially a new chapter on sustainability agreements. It includes a wide notion on sustainability, so it's not just about environmental or climate-related goals. It includes, among others, a safe harbor for sustainability standardization agreements. So, for instance, sustainable labels. There are quite a lot of criteria, and it's fair to say that's not an assessment in isolation, because there are criterions on price and market share. So it's, you have to understand the market context to some extent. And then there is also quite a lot of guidance on the exemption from the cartel prohibition. So that's Article 101, paragraph 3. And the Commission here is very cautious on how it interprets the so-called fair share criterion. So that's one out of the four criteria. And so consumers on the relevant market need essentially to be fully compensated, which was heavily criticized when the Commission kind of published a draft, but they haven't moved on that point. And the Commission is also very open for consultations. So in this case, the Commission seems to have not much experience, not much decisional practice. It's normally the other way around. The Commission has a lot of cases and it tries to codify it in guidelines. This way it was the other way around. No cases, but pressure from the public to kind of codify and provide guidance. So that's essentially the story at EU level. So Sonja, in Austria, the legislature actually decided to amend the Austrian cartel prohibition to essentially make it greener. Can you give us some more background on this?
Yes, Essentially, the greening of Austrian competition law consisted in the introduction of a new exception for sustainability. Now, Austria has become the first EU member state to introduce such a legal exemption. However, I should add that the scope of this exception is limited to regional initiatives. And now the introduction of this sustainability exception consists specifically in the amendment of paragraph 2, subparagraph 1 of the Cartel Act by adding another sentence to this paragraph.
So, the listeners may ask the question, why was this actually introduced? Why was it necessary to kind of amend the Austrian Cartel Act?
Well, according to the next explanations to the law, the intention of the Austrian legislator was to provide additional clarity since there was a wide variety of opinions and dogmatic approaches on the question as to whether and to what extent sustainability aspects can be taken into account when assessing corporations between competing undertakings from a competition law perspective. And now the idea was then to provide additional clarity in this area of tension where both companies and enforcing authorities wanted to have clearer guidance.
So when we talk about the substantive analysis of this provision, what has actually changed with the introduction of this new sustainability exemption in Austria?
In essence, the new sentence, which was added to paragraph 2, subparagraph 1 of the Cartel Act, does not introduce an entirely new exception, but it rather specifies how the condition of the adequate consumer participation should be interpreted in relation to the previous exception of paragraph 2, subparagraph 1 of the Cartel Act in the context of a sustainable corporation. So, in other words, when referring to the new sustainability exception, it actually is about the previous exception of whose the fourth condition now has been specified in relation to sustainability agreements. And this specification is precisely that an adequate consumer participation is assumed if there is a contribution to an ecological, sustainable or climate-neutral economy. However, I should add that the other three criteria of paragraph 2, subparagraph 1 of the Cartel Act must still be met in order to justify cooperation under this new sustainability exception.
So the Austrian Federal Competition Authority, they published extensive guidelines in how it intends to apply this sustainability exemption. Could you shed some light on what these guidelines try to achieve?
Yes, so on one hand, the focus was on self-assessment, so it should enable companies to assess for themselves whether a planned sustainability corporation is permissible under cartel law, and therefore it should describe the procedure for assessing a planned corporation. Now, the guidelines therefore not only intend to explain situation in which a recourse to the sustainability exception is necessary, but they also intend to show competition-neutral ways of corporations which do not require any justification. By this, they also intend to make the enforcement of the Austrian Federal Competition Authority predictable. There, I would like to emphasize that there is a possibility to consult with the Federal Competition Authority and also to obtain a comfort letter.
So, how sustainability agreements have been assessed so far in Austria after the introduction of that new exemption?
So, unfortunately, according to my knowledge, until recently, no cases have been exempted where an agreement qualified under the new sustainability exemptions. Companies have approached the competition authority with suggestions. However, as said, until recently, none of the agreements qualified for the new sustainability exemption.
Okay, so Moritz, very interesting to observe that there are very few cases in Article 101 involving sustainability. Not just in Austria, but also in many other jurisdictions. Probably some exceptions, the Netherlands, probably also Germany, a few cases. So from a perspective of an economist, what are possible explanations for this?
Well, generally we don't know, but let me recap some of the possible explanations. First, it could be that sustainability agreements are not the best choice for companies. Maybe there are easier and more profitable ways to promote sustainability. Either companies become more sustainable by themselves, or they acquire another firm, for instance, that helps them transform their business. They could be part of a subsidy scheme. I'm thinking of IPCI here, coordinating firms across the supply chain rather than horizontally. Or they could find that joint initiatives without a significant impact on competition are enough to promote sustainability. I should say I'm not aware that authorities ever expected a lot of cases, so not observing too many cases could be totally fine. Authorities did realize, though, that they want to be prepared if important cases come up, and at the same time give businesses the legal clarity to think sustainability agreements through in the first place. And then, of course, there's the skeptical perspective too. Economic theorists have found that horizontal sustainability agreements are never profitable, except for strong competition restrictions that cannot be reconciled with meaningful competition law. At the same time, we are still missing a proof of concept, an example of an ambitious sustainability agreement that is realistic, socially beneficial, but would not have been legal under previous interpretations of competition law. So if you take this view, you might think that companies were always just virtue signaling. On a more practical perspective, though, let me say that companies might simply find it hard to agree on sustainability. Asymmetries can really play a role here and make the bargaining difficult. Say if one company finds it easy to promote their production, to make their production greener, while another one finds it very costly.
So some point out that the horizontal guidelines of the Commission lack meaningful guidance on important economic questions, so particularly on how to essentially quantify sustainability benefits. Can this be also an explanation for why there are so few cases?
Let me argue probably not. The guidelines are pretty clear that quantification of benefits, so not what qualifies as benefit, but estimating the amount of the benefit, is a last resort. It is meant for those probably rare cases where benefits are not clearly above anti-competitive effects. So a more likely explanation is that it is very difficult to come up with benefits that are caused by the agreement and could not have been achieved in a less anti-competitive way in the first place. The benefits only qualify if the agreement is indispensable for the realization of the benefits. So in light of the many other alternatives to promote sustainability, it is ex ante not clear what the role of agreements is. And as said, we are still waiting for a landmark example. In defense of competition authorities, you really have to say what you mentioned in the introduction, that it's quite exceptional to give guidance without experience. Usually authorities wait for the first cases and then commit to the best practices that emerged from this case experience. Also, the substantial matter is not trivial. Sustainability benefits can come from a broad range of sources, and therefore their quantification can hardly have one size-fits-all solution. Different approaches will make sense for different benefits. So far, we competition economists have mostly looked to the environmental economics literature because environmental economists had thought about similar issues for decades. Over time, I'm pretty sure that competition economists could improve on the methods for quantification, but a prerequisite is really that there is a demand to quantify these benefits, and that is that you need to have high-profile cases of sustainability agreements.
So there are also practical reasons why there are so few cases. So it's normally quite a complex exercise, as you mentioned. The quantification itself, it's not easy and not much experience, and the outcome is also unknown. So are the quantified benefits then sufficient enough? So what's your view on this?
Yes, indeed, there is these two risks. So first, the uncertainty about the outcome, as you mentioned, but then also you have uncertainty about transaction costs. So it could be very costly to prove that an agreement is legal if you have to quantify benefits, because you need to hire specialized lawyers and specialized economists. And this makes, again, sustainability agreements less attractive for companies compared to easier alternatives, right? I think our point was that we wanted to make the possibility clear, like what is possible inside of competition law, but that doesn't mean that it may be the best choice for companies, to reiterate my first point. And I think a good lawyer will probably try to evaluate first if the anti-competitive provisions in the agreement can be relaxed, such that a quantification exercise and the resulting legal uncertainty can be avoided altogether. So to think about horizontal merger efficiencies, for example, the Commission usually dismisses them entirely, which is money not well spent for the companies. And the reason is, again, that it's very hard to come up with potential benefits of horizontal mergers that are linked to the merger. And the usual solution then is a remedy that removes the anti-competitive effects of the merger.
So you mentioned mergers, so let's now move on to the different area of competition, so merger control. and have a look at what sustainability plays here in merger control decisions so far in decisions by the European Commission. So there is an interesting competition merger briefing in September 2023, this year, a couple of months old, where the Commission discusses various cases which involved sustainability in EU merger control cases. And I think there are just two issues I want to highlight here. So first one is about market definition. So it seems that the Commission takes into account consumer preferences for sustainable products. So let's say when you define the market and possible segmentations, there is now a possible, let's call it green segmentation, and which you have to assess and also consider in your analysis. So for instance, when it comes to coffee, there's not just conventional coffee, but there are also organic fair trade coffee. Another issue is about the closeness of competitors. The Commission also looks into whether the parties involved actually close competitors also from a sustainability angle. So for instance, when looked at R&D efforts for sustainable products, are these close competitors? They both essentially have high R&D efforts in sustainable products. So in a nutshell, in merger control, it seems that sustainability is actually becoming another factor which makes it more complex in the analysis and is taken into account by the Commission in its decisions. So Moritz, besides these somewhat more legal issues, what were the interesting developments in terms of economics in merger control decisions so far?
I would say the most interesting developments are in the analysis of the circular economy, so markets that involve recycling. And traditionally, this has not been in the focus of merger cases. The Commission has now changed that in a few recent ones and came up with related theories of harm. So, for instance, the Commission examined if a merger can increase buyer power on the market for recycled scrap. The scrap is a byproduct of other products, so you have to imagine that their supply is not very elastic with respect to the price of the scrap. The companies produce the main product anyway. And consequently, the Commission evaluated if the decreased revenues for sellers of the scrap effectively increased their marginal costs and thus increased prices on these main markets, right? Which would harm consumers. It's quite a complex theory of harm, but it's worth pursuing, and it adds to the previous point that you made that incorporating sustainability aspects into competition law adds complexity.
So essentially, there are quite a lot of cases in merger control, and the analysis is becoming more complex due to sustainability. So let's move on to a different area of competition laws. That is state aid, and have a look at what role sustainability played here. So Moritz, from an economic perspective, what is the rationale actually for having state aid in the first place?
Generally, the purpose of state aid law is to avoid subsidy races. Imagine every country would pump money in their favored firm to undercut the other firms. That would no longer be competition on the merits, it would be competition on the subsidy, which is what we want to avoid with state aid control. Now, there are some exceptions to this general rule, which is why the Commission has this framework that countries can notify, and then also the Commission sometimes itself puts money on the table to fund projects. So, for example, in these IPCI projects, the Commission coordinates firms on green innovation and standards that facilitate recycling.
So, Sonja, from a more legal perspective, can you give the listeners not so familiar with EU state aid some background to the legal framework behind state aid?
Yes, so as Moritz already pointed out, in principle, state aid is not compatible with EU law. However, it can be compatible with the European internal market if the state aid serves to promote certain objectives and interests, and these interests include that the state aid serves to promote the development of certain economic sectors or economic areas. Now, on the basis of this exception, member states may grant state aid to their undertakings. However, I should add that if a member state wishes to introduce or to reorganize a state aid scheme on the basis of this exception, it must inform the Commission of its intended introduction or reorganization of the aid.
So, under the current framework set out by the Commission, what kind of state aid for sustainability is actually possible under EU law?
So the best is to look at the Commission's guidelines on state aid for climate, environmental protection and energy. On 18 February 2022, the Commission actually issued new guidelines where it softened a bit the conditions under which member states can provide support to sectors that promote environmental protection and the decarbonization of economies. And now, compared to the previous guidelines, the new guidelines allow for more categories of measures and for a higher amount of aid.
So essentially the state aid rules with regard to this area, so climate, environmental protection and energy, have not much changed in the last year. There seems to be a continuation with regard to sustainability in state aid. Do you think that's true?
Well, I would rather say that guidelines for state aid, which serves climate protection and environmental protection, were there already long before the Green Deal, whereas the new chapter in the horizontal guidelines were added only recently. So I would say that greening competition law was a more recent development with regards to classic competition law, whereas in state aid, environmental protection and sustainability objectives have a lot longer been already part of.
Can you give us some concrete examples of national schemes concerning environmental state aid that were actually permissible under the current framework of EU state aid?
Oh, actually, there are quite a lot. In the past months, the Commission has approved numerous state aid proposals. Maybe just to give you some examples, there was a French aid measure to support research and development of innovative batteries for electric vehicles. Then there was also a Lithuanian scheme for offshore wind parks, or there was a Czech scheme to support sustainable forest management. And in Austria, we also have state aid schemes for sustainability. For example, if companies want the construction of new energy efficient buildings or for photovoltaic systems, they may get state aid in Austria as well.
So to wrap up and coming back to our original question, whether competition law has become greener and more sustainable after all. So what are your final reflections after your thoughts about these three different areas? Is it true that competition law has become greener and more sustainable after all? Sonja?
Well, I would say it has become more clear how under the new and under the existing rules, companies can cooperate in a more sustainable way and thereby still comply with competition law rules. And as we have seen with the numerous state aid proposal approved recently, many states benefit from the state aid rules to support companies in their green transition.
Moritz, what's your final take on it?
I mostly echo that, so let me just say that authorities now better understand how sustainability maps into competition law, and this investment could really pay off if the private sector's sustainability efforts accelerate in the future. Businesses on the other side now have more legal clarity. Looking ahead, I'm curious to see how the guidelines will age.
So great, then thank you very much for this very interesting podcast of how sustainability interacts with antitrust, merger control and also state aid. There is still a lot to be discussed, and future cases and decisions will show what role sustainability will actually play in the future, particularly in antitrust. With that, I want to say thank you for listening and thank you to both of my speakers.
Thank you so much.
Thank you.
Thank you for joining us for today's episode of WOFTAI's Soundshot. For more information, you can contact us via email at soundshot@woftais.com or visit our website at www.woftais.com.